Hello, everyone. Good morning or good afternoon, depending on where you are based in Australia. My name is Grace Newman, and today I will be your host. A very warm welcome, and on behalf of everyone at HR Assured, thank you for taking the time out to attend today's webinar, Termination Without Tears. We expect quite a few people to be joining us today, and understandably so, this is a hot topic for any manager or business leader. So I'll just wait a minute before we begin the presentation to allow a few extra people to log on. Okay, I think that we are ready to make a start. If you've just joined us, hello, my name is Grace Newman. I'm the Commercial Manager at HR Assured. Today we will be discussing termination, a topic that would have to be one of the most challenging people management issues employers face. The reasons for letting an employee go can range from continual poor performance and disciplinary matters to redundancy or termination for serious misconduct. And because every situation is different, it's important that you follow a legally compliant process when ending an employment relationship. Failing to do so may expose your business to some unwanted risks, such as general protections or unfair dismissal claims. The termination process, it's a sensitive topic and one that raises many questions. If you happen to have a question during the presentation, please pop yours in the Q&A feature, which is located at the bottom of your screen, and we will try our best to answer at the end of the webinar. All questions will remain anonymous, and we will go through as many of the questions as we can towards the end of the webinar. Lastly, this webinar is being recorded, and we will share this with you after the presentation, so please look out for an email from myself. Next slide, please. I'd like to introduce you today to today's speakers. Olivia Perry is a senior workplace relations consultant, and she works directly with our clients, supporting and advising them on a range of complex workplace matters via the 24/7 telephone advisory service. And a little about me. My role at the company is to help businesses find the right workplace compliance solutions to ensure they are staying on the right side of the law. Now, you may or may not be aware of FCB Group of companies, but for over 30 years, we've been providing an end-to-end range of workplace compliance solutions to all types of businesses across many industries, from workplace law and migration services to HR software and now ISO certification too. FCB Workplace Law is an award-winning workplace relations law firm in Australia, and it's the backbone of where we get our expertise when it comes to managing employment law and work health and safety. The company has 5 accredited employment law specialists, the most accredited employment law specialists in one firm. Moving on to Smart Visa, we support businesses and individuals with their immigration and migration needs. Jumping over to the bottom left is Enable HR, which is our technology solution. Enable HR makes HR simple. It centralizes and automates your employee lifecycle and WHS on a cloud-based system. It manages pre-employment to employee management all the way through to termination. Things such as paperless onboarding, inductions, performance reviews, record keeping, the list goes on. Within the cloud, you can also manage hazard and incident reporting and much more in the WHS selection. QMS and best practice, they're the newest members of our family. Both QMS and best practice will be able to help out if you're looking to become ISO or NDIS certified. Lastly, this webinar is presented by our outsourced HR solution brand, HR Assured. Next slide, please. At HR Assured, we support businesses of all sizes across a variety of industries to create or enhance existing HR infrastructure, providing first-class advice and ensuring you are always meeting your obligations as an employer. To give you an idea of what we offer here at HR Assured, our service is made up of 4 complementary pillars of support. When you join HR Assured, the first thing that we would do is conduct a comprehensive HR and work health and safety audit. If at this point we identify areas of non-compliance, our team will work with you to plug the gaps and create a strategy to ensure that you are consistently following best practice moving forward and that you are fully aware of your obligations as an employer. Secondly, we will give you access to our cloud-based HRIS system. Our system helps you to effectively manage the life cycle of all employees, streamline people management processes, and access a library of legal resources managed, reviewed, and updated by our internal law firm every 60 days. The cloud provides immediate time and cost-saving benefits to any business right from the get-go. Now, here is where we're really different. Australia has the most complex employee relation laws on the planet, and straying into the wrong side of these laws presents significant risks. Incomplete, inconsistent, or incorrect advice is a recurring risk that we hear from clients who have had previously engaged certain providers within the market. You can rest assured that HRA consultants hold themselves to the highest levels of continuing professional development and delivering commercially driven solutions to your people management problems, and they're a hallmark of our approach. Our advisors are available to you 24/7, and you will have unlimited access to our team around the clock. Whether you need advice managing difficult employees, navigating a grievance, dealing with an underpayment claim, award interpretation, or discussing termination in an appropriate and compliant way, our team of experts are here for you. Finally, we have our advice promise, a protection mechanism in the event that you ever receive an employment-related claim from an employee. As I'm sure you're all aware, sometimes no matter how well you manage a situation, it can still result in a claim in the end. And this means for you that you're going to need to defend it, which can be both frustrating and very costly. Our advice promise means that in the event of a claim, we will stand beside you, representing you, with all associated costs covered by HR Assured. In a nutshell, our service can be fully outsourced HR support or a complementary support to an established HR function. But either way, we guarantee compliance and peace of mind, and all of this is delivered to you in a low monthly cost. Now, with that, I'd like to hand it over to our expert, Olivia, who will now present the next part of the webinar and the reason why you're here. Over to you, Olivia.
Thanks so much. So as mentioned, my name is Olivia Perry. I'm one of the senior workplace relations consultants with HR Assured, and pretty much our telephone advisory service, along with lots of other questions, deals with things like termination in all of its forms every day and assist our clients consistently with these internal terminations. Terminations in all natures are a very complex and ever-changing atmosphere. So I want to firstly note that every termination is different, and as such, not all size fits all. So please keep that in mind as we go through all of these slides and all through the options as well. As mentioned, it's a very complex topic with lots of different intricacies, so we won't be able to dive into every single aspect, but we'll give a really large overview of all the types of terminations today and how we can assist with that as well. In addition, I would also like to add that all terminations we suggest discussing with specialists such as HR Assured for risks when terminating, as it can be a risk-filled option when going through terminations as well. So with today's agenda, obviously, as mentioned, we'll go through reasons for termination, and a few of those will be serious misconduct, redundancy, as well as performance management termination as well, which we'll dive into that are inside minimum employment period as well as outside minimum employment period. So diving straight into termination, we're going to be looking at the meaning of dismissed. So an important question to always ask is, what does being dismissed mean actually? So naturally with this, we go straight to the Fair Work Act itself, and a lot of these navigations for termination will all be held within that Fair Work Act 2009. So we'll be looking at a few sections within that here. So you can see here that is noted within section 386, and we've got the intricacies of that within this slide here. The term being dismissed is defined as basically a person's employment has been terminated at the employer's initiative, and the person was forced to resign because of a conduct or course of conduct engaged by the employer. A dismissal here, we do note, does not mean a demotion. So that is with the exclusion of a reduction of duties or remuneration, or the end of a fixed term or fixed term agreement, or the end of a specific term training arrangement as well. So that may be an apprenticeship as an example for that. Unfair dismissal claims. So with terminations, unfair dismissal claims and dismissals are a really important aspect of employment law within Australia. This is governed again primarily within that Fair Work Act 2009. It provides legal protections to employees against wrongful termination by their employers. There's some key information around that for this as well. So pretty much the eligibility for unfair dismissal claims is to be eligible as an employee to lodge a claim. An employee must generally meet the following criteria. Firstly, being that they have completed a minimum employment period, which we'll go into that further in detail further along, but usually that'll be a 6-month period, but there are exceptions to that. They also need to be covered by the Fair Work Act. So with that definition, that does mean most Australian employees are covered. An example or an exemption for that would be a contractor potentially who aren't covered as an employee. And they must also be dismissed by the employer. So looking back at what that definition of dismissed means. For valid reasons for dismissal, employers can terminate their employees for valid reasons such as, and we'll go into detail for it, poor performance, misconduct, redundancy, or genuine operational reasons. The dismissal must also be based on substantial and justifiable reasons, which we'll go into further as well. There are some prohibited grounds for dismissal, some of those being based on race, gender, age, disability, and religion, or that there's a workplace right which has been actioned, such as making a complaint against a business or union membership. These are considered unfair and prohibited. There is also consultation and procedural fairness when termination. We'll go through a little bit of that consultation further along as well, but employers are essentially accepted to follow fair and transparent procedures when dismissing an employee, and these may include pieces such as notice period, conducting discussions prior, and allowing the employee to respond to allegations. The Fair Work Commission is the administrative body responsible for handling unfair dismissals, and employees who believe they have been unfairly dismissed can essentially file a claim with the Fair Work Commission, which will then go to the employer. The employees have, with unfair dismissals, 21 days from the date of their dismissal to lodge a claim. That is only for unfair dismissals, so noting with options such as general protections, which we'll run through further along, that is a different period of time limit. In regards to remedies for unfair dismissal, if the Fair Work Commission finds that a dismissal was unfair by the definition or harsh in some manner, the remedies can be such as reinstatement, compensation, or a payment of lost wages. This will depend on the circumstances of the case and will be at the discretion of the Fair Work Commission. I also wanted to note here there is exemptions for a small business. So a small business is those who have fewer than 15 employees in total, and those exemptions can be simplified in regards to minimum employment period being exempted, but are still subject to the core principles of the fairness. With constructive...
Sorry to jump in there, Olivia. Just wondering, for the audience's benefit, can we talk a little bit more about the what does harsh mean? What would that mean to an employer?
Of course. So that definition of harsh is also within the Fair Work Act, and pretty much it's impacted by the disproportionate unfairness or dismissal of an employee. So an example is if the employee did not commit the alleged misconduct, for example, or if they were unaware of their poor performance, for example, as well. So if they were completely unaware or untrained on their performance and then terminated on it, it could be seen as harsh for that definition. In some cases with that constructive dismissal as well, an employee can claim constructive dismissal, which occurs in the employer's actions or conduct, which makes it impossible or unreasonable for the employee to continue working. So those can be scrutinised by the Fair Work Commission as well. With unfair dismissal claims, there is a burden of proof as well. So the employer generally has the burden of proving that the dismissal was not unfair, which means that burden of proof for the employer is that they need to prove against the fact that the dismissal was unfair, and they must demonstrate that they were valid and justifiable reasons for the dismissal. So keeping that in mind with dismissals as well, that there is that added burden of proof. So as mentioned previously, we're going to now look at general protections claims. So these are in addition and separate as well to unfair dismissal claims. The general protections, again noted in the Fair Work Act, are a set of provisions that protect the workplace rights and freedoms of association of employees, independent contractors, and prospective employees. So quite a broad range in comparison to your unfair dismissal claim options. These provisions aim to ensure that individuals are not subjected to adverse treatment, discrimination, or unlawful conduct by employers or prospective employers. So there's a bit of an explanation for here. Essentially, there is protection of workplace rights, freedom of association, protection from adverse action, protection from discrimination, and protection from coercion, protection from misrepresentation, complaints and enforcement, and there's a reverse onus of proof on that, which we'll go into a little bit more. So there's quite a lot in terms of general protections. This is another one that, as mentioned at the start, is quite complex. So I'll only really slightly go into general protections because there is quite a big risk profile with these. And because of that broad nature of general protections can be quite complex in nature. So with those protection of workplace rights, essentially if an employee has exercised a workplace right, and I'll give a little bit of an example of that. Let's say an employee has injured themselves, potentially they have broken their arm and has asked for a period of leave or some constraints and support during that period of treatment for them. If the employer had made a decision then on that basis to terminate the employee because of that, there would be potentially an aspect of a general protection claim available for them. The Fair Work Act protects the individual's right to join or not join a union as well. So that can be another example of an adverse action based on their union membership or non-membership as well. With adverse action, this refers to actions taken by employers or other parties that are detrimental to the employee's prospective employment interests. So that can include dismissal, demotion, discrimination, or any harmful treatment. Employers cannot take adverse action against employees, so it's only for employees against employers for exercising their workplace rights or engaging in lawful industrial actions. Again, looking at that discrimination element, if you are being discriminated against as an employee based on race, colour, sex, sexual orientation, age, disability, religion, political opinion, or social origin, that is an element of what we can claim for general protections as well. And there is also aspects for employers or prospective employers that they cannot provide false or misleading information to employees about their workplace rights, entitlements, or obligations. So there's quite a lot of elements with that general protections, and again, why it can be complex as well. Touching on that reverse onus of proof. So in cases where an employee alleges a breach of general protections, the burden of proof may shift to the employer. That means, again, the employer may be required to demonstrate they did not take adverse action or discriminate against the employee. It's important to note that these general protections provide a broad range of rights and safeguards for the employees, and employers must be aware of their obligations under the Fair Work Act to avoid legal disputes and penalties. Employees who believe their rights have been violated can obviously seek legal advice or pursue through the appropriate channels, such as the Fair Work Commission and the courts, much like they can with unfair dismissal. So who can actually claim? We have touched on that, but just wanted to put it in a little bit more of a brief description here. So not everyone can make an unfair dismissal claim, as I've mentioned. So award or EA covered employees can. Non-award or employees can also claim as long as they're below the high income threshold. So that does change every year as well. So noting that within the generally 1st of July increases. Casual employees can make a claim, as we mentioned, through general protections, but they also can if they are noted as regular and systematic as an employer. And fixed term and seasonal employees, along with their apprentices and trainees, are not eligible to make an unfair dismissal claim unless their employment has been terminated earlier than when it was due to end.
And what about contractors, Olivia? What is regular and systematic?
Yeah, good question. So contractors are generally people who are outside of that jurisdiction for unfair dismissal. However, there are some aspects for general protections within, as mentioned. With the regular and systematic, that does come down to, in addition, which we won't go into with casual conversion, but when looking at casuals, you do need to look at whether you're a large employer, so again, that larger than 15 employees, as well as whether the employee as a casual has been there for over a year and had those consistent and regular shifts as well. So something which we definitely suggest discussing with options like your telephone advisory line to make sure that when you are going through termination of a casual, you're not meeting any of those thresholds. So now looking at some jurisdictional objections. So with these jurisdictional objections, if the employee is within their minimum employment period, which we'll touch base on a little bit further along as well, if the application is out of time, so again, looping back with those 21 days, if the individual was not an employee, so another aspect that we need to look at with those casuals and with the fact that there's contractors and whatnot as well. So that's another option for those objections. If the dismissal was a case of genuine redundancy, which we'll look at in some slides further along as well, and again, if they're a part of that high income threshold. So pretty much these are all objections when looking at unfair dismissal that you can object against the claim. So now we're going to go into a bit of a deep dive into redundancy. So when does a redundancy occur? So the redundancy process can be quite complex. Pretty much a redundancy can occur whenever there's no need for an employee's role in particular. It does need to be a genuine redundancy, and we would always suggest going through a really scrutinized internal process for what we suggest maybe a redundancy matrix, where you would look at each role and make sure that there's genuinely no need for that role, because it can have an element of an ingenuine redundancy if you had not gone through that proper process. When looking at entitlements for redundancy pay, well, there'll be a little bit of a slide further along as we'll go through that element, but pretty much it does just look at your continued service of the employee, as well as your statutory entitlements. The process can be quite lengthy. It does differ between each modern award as well, so please keep that in mind. But pretty much it's just a consultation process, and we'll run through that as well. So as mentioned, an example is if there's a change in operational requirements of the employer. If these changes mean that the work performed by the employee is no longer required by anyone. And as mentioned previously, you need to really scrutinise whether that's actually a genuine redundancy or not. And that's something you'd look at internally within. So with the redundancy process, it's critical in effecting a redundancy that we follow through the compliance and obligations process. Those are all within Section 389 of the Fair Work Act, and is a complete answer in relation to an obligation for unfair dismissal claims as well. So with those key requirements, we obviously need to make sure that we're checking it's a genuine redundancy and the job is no longer required to be performed by anyone firstly. Secondly, we need to make sure that we're fulfilling our consultation obligations. So we need to make sure that the employee is either under a modern award or an enterprise agreement or award free, and whether that applies to the employee for consultation processes. And there were no other roles within the employer's business or an associate entity which could be reasonable to redeploy the employee. So essentially when looking at redundancy, it'll either be firstly that redeployment option or a potential redundancy and redundancy payout. So with looking at involving redundancies and expansions, there needs to be a change in operational requirements as well. And that can involve expansions within the business to alter the role in its parameters as well. So potentially changing the position description or the role title, that can be an operational element for redundancy as well. So with that process consultation, as mentioned, the first thing we'll look at is whether a modern award applies. That does mean that we'll have some clear consultation requirements. However, with best practice, if there's no modern award applied, we do consider that there's very high benefits in consultation process anyway. The consultation requirements are within the process of inviting the employee, allowing 24 hours notice as well as support person if possible, and then going through discussing the redundancy, the reasoning behind it, and what that may mean for the employee. You would also give the employee some time and some benefits of being able to discuss with their family, potentially mull over their decision, maybe look at a redeployment option if that's what you're offering, and gives them a chance to make that decision on that process as well. From then, you'll then invite them into another consultation process where you'll be actioning any of that redundancy, going through the continuation of that redundancy process. So as mentioned within that process, redeployment is an option. A person's dismissal would not be a case of genuine redundancy if it's been reasonable in the circumstances and the person has been redeployed within the employer's business. The offer of redeployment extends to roles of a different level, nature, and even geographical location, as long as the employee agrees and there's the appropriate skills or would have the appropriate skills once trained. So that means even if you think the employee won't take up the role, it's always a good idea and best practice to still offer that to them. So entitlement to redundancy pay. We won't go too much into detail. Again, it's quite a complex matter and does vary quite heavily on different circumstances. But essentially, we're looking at employed on a permanent basis, employed for at least 12 months. The employer is not a small business employer, so again, that 15 employees or less. Not employed for a specific time, task, or season, so that may be a fixed term contract as an example. And then there is also that entitlement linked to the amount of length of service as well. And then also that payment at base rate of pay and your other statutory obligations such as annual leave, potentially long service leave. This is just a brief outline again of your redundancy pay. So as you can see, it's quite incremental on the basis of that continued service. Entitlement to notice with redundancy pay. So an employee who's been terminated must be provided with the applicable notice. There is a note here. So if an employee is over the age of 45 and has completed more than 2 years continuous service with an employer, they must be provided with an additional week's notice. So keep that in mind when going through a redundancy process. As mentioned, it's quite a complex process and there is a lot of elements, but looking to note that that 45 and above is something that you may need to take into consideration. Again, a little table here is on the basis of continued service, and as you can see, it's quite incremental on that continued service process.
All right, thank you so much, Olivia. All of the information that you've shared has been incredibly insightful, and I'm sure everybody on the webinar today will agree. And I guess it clearly demonstrates the importance of businesses ensuring that they are following the right process whenever considering termination to mitigate any costly risks. Now, we know that workplace compliance is a must-have in any business, and there is no escaping the law. If you have any concerns with your business, the best thing that you can do is talk to a professional. And this is something that we can support you with. Today, we're offering 10 businesses on this webinar a complimentary consultation to discuss your workplace compliance. We'll ask you a few simple questions, discuss your current HR processes, and discover ways that your business can improve. It's the best way to reduce your risk profile and avoid reputational damage, expensive legal costs, and large penalties. At this stage, if it's appropriate and we identify gaps, or if there is support that you need right now, we can talk to you about how HR Assured can support you moving forward. It's a no obligation consultation and will typically take around 45 minutes to an hour of your time. To arrange a consultation call, simply scan the QR code on the screen, or you can click on the link, which is now in the chat. I'm going to give you just 30 more seconds to allow everyone enough time to scan and complete the form. All right, I hope that's giving you all enough time. I think we're ready to get on with the rest of the webinar.
So dismissal now. So we're moving out of redundancy now, and now looking at terminations within minimum employment period firstly. So in Australia, the termination of employment during the minimum employment period is subject to specific rules and regulations, again, or within the Fair Work Act. The minimum employment period is often referred to as minimum employment period, can also be referred to as probationary period. Essentially, it's that initial period of employment during which protections and entitlements may be limited to employees. So some important information with that is the length of the minimum employment period. Generally, it's about 6 months from the start of employment for the employees. However, some awards and contracts may specify a different amount. Also taking into note the minimum employment period may alter on the basis of how large your employer is as well. So termination rights during minimum employment period. So during this period, employees may have limited access to certain protections, one of those being unfair dismissal claims. And it means they typically cannot lodge an unfair dismissal claim if their period of employment has been terminated during probationary period. There are some exemptions to this. For example, employees can still make an unfair dismissal claim if their termination is discriminatory or in a breach of a general protections provision. Employers may include a probation period clause in employment contracts, and this is specifying that the first few months of employment are considered probationary. During this time, shorter periods can apply if the employer wishes to terminate and can make that discretionary decision on their employment relationship. So if there is a dispute over a termination during the minimum employment period, employees can seek advice or assistance from the Fair Work Commission, and the Commission will advise on whether the fairness of the termination is unharsh or unjust. Within the Fair Work Act as well, there are limited certain protections during the minimum employment period. So employers must still comply with other employment laws, such as anti-discrimination legislation and work health and safety regulations. Another key tip here is employers should still maintain really clear records of probationary periods, and that includes any performance management evaluations, any feedback which was being provided to employees during this time. Effective communication with the employees about their terms and any performance expectations is essential and really helps if any claims come forward from the termination. So we'll now look at termination outside of minimum employment period. I'm going to focus heavily here on performance management because that is tend to be how we will terminate when they are outside of minimum employment period. So performance management is a critical process for employers to address and improve an employee's job performance. While the Fair Work Act does not explicitly outline a formal process for performance management, it does contain provisions which relate to the employment relationships and dismissal. So effectively, we are creating a performance management to adhere to those dismissal applications. That indirectly affects how performance is conducted because we are essentially trying to assist with any claims that come forward. So as mentioned, no specific step-by-step process. However, our HR Short outlines, as well as online HRA Cloud, does go through certain processes and best practice to try and make sure that we're really mitigating every risk in termination. We do need to really look at procedural fairness and natural justice. So again, whilst there's no formal process outlined, employers are expected to adhere to principles of procedural fairness when conducting performance management. So this would include giving employees notice, a fair opportunity to respond to concerns, and access to support or representation if needed. As noted, these would be employees outside of their minimum employment period. So one key aspect to consider is the risk of unfair dismissal claims, as well as general protection claims as well. And the Fair Work Act, as we've mentioned, establishes a criteria for that. Another tip, which we'll run through again and again, is effective communication and making sure that we're keeping documentations of all aspects of these formal processes. So employers should clearly communicate performance expectations, provide regular feedback, and discuss any performance issues with the employees ongoing and potentially formally in writing as well. We need to make sure that we're having open and transparent communication with the employee, and this can help with misunderstanding and disputes as well. Written documentation outside of minimum employment period, but also inside employment period as well, is really critical and should maintain accurate records of performance management discussions, including things like performance improvement plans, performance appraisals, and any related correspondence as well. The primary goal of performance management should be to help the employees improve their performance. So making sure that employers are providing support, training, resources, and assisting employees along the entire journey of performance management is really critical to that process. Another aspect to add to that as well is considering the individual's circumstances. So should the individual have specific circumstances when addressing performance issues, such as health, access to resources, these should all be taken into consideration when performance management. Employers should also make sure that their performance management practices are in line with the awards, enterprise agreements, and any contracts for employment. Another tip here is review and feedback. So regularly reviewing and giving feedback to employees' performance can help track progress and identify any areas for improvement early on. This process should be ongoing and not limited to just performance management procedures. It can be something that we go through with learning and development and making sure that we're continually discussing with the employee. So another option for termination outside of minimum employment period is in options of serious misconduct. So to mitigate risk in termination outside of the minimum employment period, the employer can either terminate following a performance management process, as we mentioned previously, or terminate following serious misconduct. So with the definition here of serious misconduct, it's another one that's of course noted within the Fair Work Act, and it generally involves actions or behaviours that are so severe that they undermine the employment relationship to the extent that continuing the employment is no longer viable. So an example of that may be theft, fraud, violence, harassment, or other significant breaches of workplace policies. Employers are expected to adhere to still principles of procedural fairness when dealing with serious misconduct, and it's crucially important that we follow these steps here outlined. So firstly, again, giving the employee at least 24 hours notice of the allegations. That includes giving an invitation to a misconduct meeting, which has all of the allegations listed in detail. The second there being providing them with an opportunity to respond, again with a support person offered. Third piece being conducting a thorough and impartial investigation into the allegations, and then providing the employee with an outcome meeting and an outcome of all of the allegations that have been noted. When looking in cases of alleged serious misconduct, employers may suspend the employee with pay during this conducting of an investigation. The suspension should be a reasonable period of time and should not be punitive in nature. When looking at the investigation process, it's crucial that employers should conduct a fair and comprehensive investigation into the alleged misconduct, and this may involve interviewing other parties, gathering evidence, and maintaining confidentiality as much as possible. With the termination decision, once completing the investigation, employers should carefully consider the evidence and make an informed decision when regarding termination. The decision should be communicated to the employee in writing always and outline the reasons of dismissal. Employees, as mentioned previously a few times, have the right to lodge unfair dismissal claims with the Fair Work Commission if they believe their termination, including serious misconduct, was unfair or unjust, and employers should prepare for their defence for their decision with proper documentation and evidence. So just a few practical tips here. I've mentioned a few of these already, but always consider decision-making structure. So who is recommending, who is deciding, who is an impartial decision maker in potentially those investigations, for example. Isolate those decision makers and ensure where possible they do not have a special interest in the outcome. So again, unbiased in nature. The decision maker must know why they are terminating and be across all of the elements of that aspect. I'll keep going on about this one because it's always very important, but a good paper trail is critically important through these processes. As well as being fair and consistent is very important as well. Something to note, don't rush the process. It can be a really stressful process going through a termination. So again, we do always suggest that you go through your specialised employers like us to assist with that process. And it's always better to get it right the first time. So don't shy away from revisiting decisions if affected by error. Also note, don't forget to provide employees with the opportunity to respond to all concerns. That's sometimes an aspect that can be missed along the way, and we can just move straight to termination sometimes. So making sure we don't rush it and providing those opportunities is crucially important to make sure that we're going through with a fair and just process for termination.
All right. Okay, before we answer your questions, I want to remind you again about the consultation. I did just do a very quick check. There's a few that's come through pretty quickly, and we do have a couple more places left. If you would like to take advantage of this offer, again, you've got the QR code there. You can register your interest. It will only take a few minutes, but could potentially save you and your business from unwanted risks, not to forget the penalties and legal costs that are associated with non-compliance. We will ask you a range of questions that relate to your HR procedures, and in return, you'll know where your workplace compliance stands. Now, let us jump into your questions. Thank you so much to the attendees that have put their hands up to get some questions answered. There's quite a few in here, and some of them are quite complex as well. We'll get through as many of these as we can. I am conscious of time. If we can't get through to your question today, we'll be in contact with you after the webinar. Right, here we go. Olivia, you ready?
Yep.
Okay, question number one. What if my employee just leaves one day and doesn't return?
Yep, so that's a form of termination. Again, as mentioned, we didn't go into all the forms of termination, and they are very different from every different scenario. But essentially that falls under your process of abandonment of employment. There's a process that you need to follow for that in terms of sending information in terms of a letter for that process of abandonment of employment, making sure that we check in with the employee as much as possible, like calls, emails, trying to get in contact, and then we can move to termination in most circumstances. But again, quite complex and always ever changing. So something you would always suggest having a discussion with people like your telephone advisory service like myself.
Thank you. Again, another complicated process. What if my employee refuses to undertake performance management?
Yeah, that can be. Yeah, it can be quite a difficult situation as well. Essentially, there's always reasonable business direction from an employer to an employee, and you'd need to look at that aspect when going through that process. However, it is a really, again, complex one and something you'd have to navigate ongoing with the employee, but it can be a reason potentially for termination in your early stages, even when you are outside of probationary period, because the employee does have that aspect that they do need to undertake performance management if it's reasonable.
Awesome. And then I'll make this the last one today. My employee works from home. Will this affect the performance process?
Yeah, lots of people working from home now following COVID, which is lovely. It shouldn't affect the performance process at all. I think it's just really important to make sure that when you do have people working remotely or working from home, communication, again, still your written processes, and just touching base as much as you can, maybe having a weekly catch up if you're a manager of those employees, or facilitating helping your managers having those weekly catch ups, really making sure that even if they aren't underperforming, you're still having those performance improvement plans and going through learning and development. So you've still got that structure underway should they be underperforming in any way. So you can really be on top of them and helping them and managing them. Not only is it good for termination, it's also really good for making sure the environment for the employee is really good as well. So they're not feeling left out when maybe working at home too.
Awesome. Thank you so much, Olivia. I think managing employees and people in general can be really tricky, especially as we're starting to come to performance issues and then termination. So I think this has been incredibly helpful. And then again, for anybody wanting to find out a little bit more about how we can support you further, if you've got any questions about any of these complex matters, please do get in touch. Now, that's it from us today. Thank you so much again for spending some time with us to attend this webinar. And we hope that you've taken advantage of the initiatives that we're offering, but more importantly, that you've walked away with some information that's valuable to you and to your business. We do these types of webinars pretty regularly, so keep a lookout for the next one. We'll be in contact with you soon, but for now, take care, stay safe, and enjoy the rest of your day.